not to be confused with the current United States Courts of Appeals. The United States Circuit Courts were the original intermediate-level courts of the United States federal court system. They were established by the Judiciary Act of 1789. They had trial court jurisdiction over civil suits of diversity jurisdiction and major federal crimes. They also had appellate jurisdiction over the United States District Courts. The Judiciary Act of 1891 transferred their appellate jurisdiction to the newly created United States Circuit Courts of Appeals, which are now known as the United States Courts of Appeals. On January 1, 1912, the effective date of the Judicial Code of 1911, the circuit courts were abolished, with the remaining trial court jurisdiction transferred to the U.S. District Courts. During the 100 years that the justices of the Supreme Court rode circuit, many justices complained about the effort required. Riding circuit took a great deal of time and was both physically demanding and dangerous. However, members of Congress held firm to the belief that circuit riding benefited the justices and the populace, and they turned a deaf ear to the corps of justices that desired to abolish the practice. The Judiciary Act of 1869 established a separate circuit court, but the act required that Supreme Court judges had to ride circuit once every 2 years. However, this came to a final end in 1891 when the Circuit Courts of Appeals Act was passed. The net result of riding circuit was that, in many cases which ended up before the Supreme Court, a member of the Supreme Court had already heard the case and issued a ruling. In a real sense, the Supreme Court was, in such cases, acting as an en banc panel, i.e., hearing a case upon which one of the members had already passed judgment. Organization. Although the federal judicial districts were grouped into circuits, the circuit courts convened separately in each district and were designated by the name of the district, not by the name and number of the circuit. The designation of circuit served only for the purpose of designating the districts in which a particular Supreme Court justice, and later a circuit judge, would sit on the circuit court. The circuit court districts were usually, but not always, the same as the districts established for the district courts. Each circuit court was composed initially of 2 Supreme Court justices and the district judge of the district, although in 1793 Congress provided that a quorum of 1 justice and 1 district judge could hold a court. After 1802, only 1 justice was assigned to each circuit, and a quorum could consist of a single justice or judge. This circuit riding arrangement meant that the Supreme Court justices spent the majority of the year traveling to each district within their circuit to conduct trials, and spent far less time assembled at the Capitol to hear appeals. The burden of circuit riding was somewhat alleviated by the appointment of circuit judges under the Circuit Judges Act of 1869, but not abolished until the creation of the Intermediate Courts of Appeals in 1891. In 1801, Congress created the United States Circuit Court of the District of Columbia, a circuit court for the District of Columbia. This court had the same original jurisdiction and powers as the United States Circuit Courts, but, unlike those courts, it continued to have its own judges even after the repeal of the Judiciary Act of 1801, and had appellate jurisdiction over justices of the peace and other local courts of the district. The District of Columbia was not enumerated among the federal circuits at the time. This court was abolished in 1863. Judges. Although any district court judge could be authorized to act as a circuit judge, only 50 judges solely designated as circuit court judges were ever appointed. These can be broadly categorized into 4 groups: judges appointed pursuant to the Midnight Judges Act on or after February 20, 1801, and thereafter removed from office with the repeal of that Act on July 1, 1802. Judges appointed to the D.C. Circuit, abolished on March 3, 1863. Judges appointed after 1869 pursuant to the Circuit Judges Act of 1869. Those in office on June 16, 1891 were transferred to the newly created United States Courts of Appeals by operation of law, that is, without action on the part of the President. One judge appointed to the California Circuit, established in 1855 and abolished on March 3, 1863. 3 Circuit Court judges, Samuel M. Blatchford, David Josiah Brewer, and William Burnham Woods, were later appointed to the United States Supreme Court. Circuit Court judges appointed pursuant to the Midnight Judges Act, judges of the D.